Welcome back, folks, to another episode of American Genesis, where we are discussing the creation of America's scripture. This is the next to the last presentation we're going to be doing today. Or this week, next week, we will finish this up, and then we are going to start a brand new set of presentations on the American Civil War. Speaking of that, I've been working on these for the last few months, and just so happens that I was just working this past week on the assassination of Abraham Lincoln. Today happens to be the 160th anniversary of Abraham Lincoln's assassination. Of course, he didn't die till the next day, but he was actually assassinated on this day 160 years ago. That happens to be the last photograph taken, and I think you can see the amount of stress that obviously the war had put upon the man. So that will start not next week, but week after next. I'm real excited about it. I think it's going to be really good. So I'll be looking forward to having many of you with me. Well, let's review back on what we did, the last couple of weeks ago. Um, 2 weeks ago, we began looking at the 17 amendments that have been added to the United States Constitution since the ratification of the original document, plus the Bill of Rights. So remember, the first 10 amendments were part of what's called the Bill of Rights, which were added in order to get the Constitution ratified. Since that 200 plus years, there's only been 17 amendments. And remember, most of those came about because of a crisis like the Civil War, because of the cleaning up language that had inadvertent problems associated with it, social movements, expansion of the electorate, things like this. So there's not been a whole lot of changes to the Constitution. So last week, or 2 weeks ago, we looked at the 11th Amendment, which granted states sovereign immunity, meaning they were protected from lawsuits filed by citizens of other states or foreign countries. That was a cleanup amendment. And then the 12th Amendment was added because of the crisis in 1800, where the vice president almost became the president, which would have been a real disaster since it was Aaron Burr. And he had somewhat of a checkered past and would have a much more checkered future. So they had to clean that up to make sure that the electors in the Electoral College voted only for a president and a vice president, not, two votes. It was really a kind of a mess. Then we looked at the 13th Amendment, which was very straightforward. It abolished slavery, came about in the early part of 1865. And then we looked at the 14th Amendment. We began looking at that. And at its core, the 14th Amendment was created to grant citizenship to freed slaves. However, it did much more than that. And we started looking at some of the things that it did besides granting citizenship to freed slaves. For instance, it established the concept of birthright citizenship. Now, there's a lot of dispute about exactly, what that means, and I suspect sooner or later the Supreme Court will address that again because that's kind of a hot topic right now in America. And it also established a process for naturalization of non citizens, how a non citizen can become a citizen. That's where we left off 2 weeks ago. So let's get in. Pardon me. I forgot one. We reviewed the concept of privileges and immunities, which is really, I think I really kind of confused you all last week. Basically, all privileges and immunity does is protects the rights of a citizen from interference from other states. You can't be denied the right to vote in California just because you once lived in Missouri. You have to establish residency and you have to establish, all this kind of stuff, but you can't be, kept from voting in California because you once lived in Missouri. So, with that being said, let's look at the remainder of the 14th Amendment. Probably, as it turned out, The citizenship clause granting citizenship to the freed slaves, while important right at that moment, probably didn't have as lasting effect as did what's called the due process clause and the equal protection clauses of the 14th Amendment. So that's what we're going to talk about in part today. The due process clause of the 14th Amendment deals with the administration of justice and thus acts as a safeguard from arbitrary denial of life, liberty, or property. And it applies only to the states since it's identical to the due process clause of the Fifth Amendment. The language in the due process clause of the 14th Amendment is almost identical to the due process clause of the Fifth Amendment, only it applies to the states, not to the nation as a whole. Now, the courts have ruled there's two types of due process. There's what's called procedural due process, which requires government officials to follow fair procedures before depriving someone of life, liberty, or property. In other words, if you're going to deny somebody their life by capital punishment, there has to be fair procedures established. We saw that in the Eighth Amendment. There's also what's called substantive due process, which protects people against laws or policy that exceed the limits of governmental authority. So there's also due process, which means the government can't go out of bounds and do things that it shouldn't do. An example, and I'm just pulling this out since it just recently happened, where I think we're probably all aware that President Trump deported a large group of people to El Salvador that were non-citizens and alleged members of a gang, a South American gang. One judge jumped in and said, you can't do that because even though they're non-citizens, you denied them their substantive due process. They didn't have a right to challenge that deportation. Of course, ultimately, the Supreme Court stepped in and said, no, he did have a right to do that. That is within his legal rights as Commander in Chief and President of the United States. That's what we're talking about here, substantive due process and procedural due process. Now, there's been a whole lot of Supreme Court cases that had to do with due process, and we've talked about some of them. A lot of them had to do with abortion. Remember Griswold versus Connecticut established the right to privacy, which ultimately led to the right to abortion in Roe v. Wade. And then there was this process of a right to die, Cruzan versus Missouri. There was that had to be established. Although in Cruzan's case, the courts came back and said, no, you don't have a right to do that. The state has a vested interest in whether someone can be deprived of their life. As it turned out, Cruzan was allowed to go ahead and be taken off the ventilators anyway. Then there was Planned Parenthood versus Casey, which restricted abortion and began the process down where, of course, ultimately led to Dodd case. We've talked about all of these, okay? Now, here's a couple we haven't talked about and have been in the news a lot in the last decade. The first one was Lawrence versus Texas, which decriminalized private sexual acts between same-sex couples. So let's look at this, okay? Because this has to do with homosexual rights. John Lawrence and Tyron Garner, Texas citizens, were arrested and convicted under Texas law that prohibited deviant sexual intercourse between people of the same sex. Texas had a law in the books stating that was deviant, acts, and they could be arrested. This is only since 2000, folks. It's not anything real old, okay? So the question arose, did Texas law violate the due process clause of the 14th Amendment, which protects fundamental rights? In other words, was their substantive due process denied? Did Texas law go too far in denying them the right to have, sexual acts in the privacy of their own home and whatever? And the decision was 6-3 in favor of the defendant. Said, yes, Texas went too far. What these two men did in the privacy in their own home was up to them. As long as it was consensual and there was no problems there, that was their thing. They said they violated the 14th Amendment that says the right to engage in private, consensual sexual conduct is a fundamental liberty protected by the Constitution. What it did was decriminalize same sex conduct nationwide and established a right to privacy in intimate matters. That ultimately led to the next case, which had far reaching ramifications. Obergefell versus Hodges, which upheld same sex marriages. What happened was this: 2015, the case involved several plaintiffs who challenged a state law which banned same sex marriage. They said they claimed that they had a right to be married. Almost every state in the union had a law against same sex marriages, and they said that's unconstitutional, based on the Lawrence versus Texas case. And so the Supreme Court took the case and it was pretty controversial. Does the 14th Amendment require a state to license a marriage between two people of the same sex? And does it require a state to recognize a same-sex marriage performed in another state? And the decision was a narrow decision, 5-4 in favor of the plaintiffs. This was during the Obama administration, and the court had not yet shifted to a more conservative court. Would that decision have been reached in the current court? I don't know. Okay. That's probably a question we're never going to find out, because I think probably at this stage of the game, you're not going to see a whole lot of movement away from that. So 5-4 in favor of the plaintiffs. The court held that the 14th Amendment's due process clause protects same-sex marriages and required all states to recognize these marriages. This case led to the legalization of same-sex marriage in all 50 states. Huge case, folks. I think we're all aware of this, that this had great ramifications on society in America. And there's a lot of people that still don't agree with it, but that's the law of the land. So finally, of course, we had the Dobbs case, which overturned Griswold, Roe, which basically said, no, there's not a right to privacy and when it comes to abortion. And that if that's a decision that needs to be made at the state level, that's what the Supreme Court said. So the due process clause has also been interpreted by the courts as allowing the application of the Bill of Rights to the states by a process known as incorporation. We've talked about this a lot. Now, it's debatable. Remember, this is where the 14th Amendment can be used to apply the constitutional limits of the Bill of Rights to the states. It's debatable if that's exactly what the framers of this amendment wanted. I've done a lot of reading about this, and it's not quite black and white that that's what the framers intended. But nevertheless, that's what the Supreme Court has ruled. They have ruled that incorporate all the provisions of the First, the Second, the Fourth, the Fifth, except for the grand jury, the Sixth, and the Eighth Amendments. So almost every amendment has been incorporated now, with the exception of the third, which is quarterly truth, which has never been a big problem. The Seventh Amendment has not been. The Ninth Amendment hasn't been totally. Parts of it, although the part where we had the right to privacy, and the 10th Amendment was kind of a cleanup language. So, the due process clause of the 14th Amendment is really, really important. In fact, cases I've said before, next to the First Amendment, it may be the single most important amendment in the Constitution of the United States. So that's the due process clause. Now, involved in that is also what's called the equal protection clause. The equal protection clause of the 14th Amendment was outright designed to assure persons of color that they could not be denied the civil rights under the law that were given to white people. That's exactly what it was designed to do. It came about because of something called the Black Codes. After the Civil War and after the slaves were freed, the Confederate States wasted no time in establishing what were called Black Codes, which were designed to restrict African Americans' freedom and to compel them to work for low wages or no wages. It was, we're going to talk about this when we get into the Civil War, exactly what the Black Codes were. But for right now, that's all you really need to know. It was designed to circumvent the abolition of slavery. So when the 14th Amendment was written, they put this in there to make sure that these Black Codes should not have been put in. It's important that the Equal Protection Clause had been held to apply to both citizens and non-citizens. Very important. What I just tell you about the case where these South American immigrants that have come to America illegally, and have entered into the United States illegally, and were deported because of their reputed gang ties. This one judge said, hey, even though they're non-citizens, they have a right to equal protection under our laws. Supreme Court said that is true. However, in this particular case, the president has a right under his powers as the commander in chief. So, the Equal Protection Clause applies both to citizens and non-citizens. It also applies to all other races other than African Americans. For a long time, it did not apply to Native Americans because the Native Americans were considered, the ones that were living on a reservation were considered to be, a nation unto themselves. Since that time, that's been, done away with by different laws of Congress and by a Supreme Court decision. Now, of course, Native Americans are, and they are considered citizens. The Supreme Court has also held that corporations enjoy personhood under the Equal Protection Law. This has to do with campaign finance. And so you cannot deny corporations their equal protection in the law. The Supreme Court has ruled that they have a right to equal protection. Very controversial decision in campaign financing. It completely threw campaign finance reform under the bus. Let's put it that way. However, the good old Southern states, they had a way of getting around a lot of things for a lot of years. In 1896, the Supreme Court had to rule and whether or not racial segregation could be allowed as long as separate but equal facilities were permitted. So there's something the Jim Crow era, and we'll talk about this when we get into the Civil War if you stay with me. The Jim Crow era was this era after the Civil War where laws were passed in the southern states that allowed for racial segregation. And you would see things like these water fountains, black or colored and white, bathrooms separate, schools separate. In 1896, the Supreme Court had to rule on whether or not the separate but equal doctrine was legal in a case called Plessy versus Ferguson. I'm sure a lot of you out there remember particularly the lower part of these scenes. I can barely recall. I'm just in my late 70s, so this occurred when I was, a young kid, when they outlawed this separate but equal thing. But I can still remember going to Springfield and seeing separate bathrooms. I can still recall that. Schools in Springfield, were segregated. Black students went to one school, white students went to another. This was brought about because of Plessy versus Ferguson. So here's what happened in 1896. Homer Plessy was a 7th, 8th Caucasian man. And he decided he was going to sit in a whites only railway car in Louisiana, LA. Okay, so he decided he was going to sit in a whites only railway car in Louisiana. He did not appear to be black, but because people knew him, they knew of his ancestry. And, in the southern states, they had everybody's business was everybody's business. And they knew he was 7th or 1/8 African American, black. So the question, did Plessy's arrest violate the 14th Amendment Equal Protection Clause? He sued, said, hey, I have a right to sit, I have equal protection of the laws according to the 14th Amendment. The Supreme Court, and probably one of the 2 or 3 worst rulings in Supreme Court history, ruled that the law that allowed him to not sit in whites only railway seating was constitutional. What they said was this: the court held that the law was constitutional and established what was known as the separate but equal doctrine, which said that the 14th Amendment established legal equality, but not social equality. Boy, that's a fine line, right? That separates separate but equal facilities did not inherently imply inferiority. Well, you tell that to these kids up here sitting in the black school, okay? It didn't inherently imply inferiority, but it most certainly did imply inferiority in most cases. This ruling had a profound effect on ushering in the Jim Crow era and solidifying it. And you saw after this, up until the 1950s, segregation in public accommodations, education, almost every other aspect of the United States, particularly in the South, where these laws went into effect. So this was a huge decision and has routinely been called, along with Dred Scott and another decision we're going to talk about in a few minutes, as one of the single worst decisions in Supreme Court history. Plessy versus Ferguson, in retrospect, was just a terrible, decision, because obviously separate but equal wasn't equal. It was separate and unequal in most cases. So that had to be overturned, but it took almost 60 years to overturn it. 1954, Brown versus Board of Education. Once again, the case came before the United States Supreme Court whether or not segregated black and white schools were equal, which they almost never were. Let's be honest. I think we're all aware that they probably were not equal. I can look back at my own situation coming from the Springfield, Missouri area, and I can remember when I actually have been in classes at OTC in the old black school, high school in Springfield. That's part of the OTC campus. And I can remember sitting in the classrooms of that building thinking, this was once the black high school. And trust me, it was not. Even though it had been remodeled, it was still a long ways from being as nice as what the other buildings were. So the Supreme Court said the practice was inherently harmful to black students and was unconstitutional. This just absolutely overturned decades of segregation in America and ushered in a whole new era of landmark civil rights cases, which expanded the coverage of equal protection. So let's look at the Brown case. This is Linda Brown and her family in, I think, Topeka, Kansas. I believe that's where the case was originally filed. Brown stemmed from several lawsuits challenging the constitutionality of segregation in schools, arguing the separate but equal doctrine was a wrongly decided doctrine. So, was it? That was the question. The Supreme Court had to come back and say, Was the Supreme Court wrong in Plessy versus Ferguson in 1896? Did they get it wrong? And unanimously, the Supreme Court said, yes, they did. They said this was absolutely not legal. It was not constitutional. It should have never been constitutional. And said the separate but equal facilities are inherently unequal, and that the doctrine violated the Equal Protection Clause of the 14th Amendment. The case also served as a catalyst for desegregation in many other areas: housing, public accommodations, higher education. And in a follow-up case, the court directed district courts and school boards to proceed with desegregation with all deliberate speed, which I think we can remember. Most of us remember the Little Rock Nine, where the governor of the state of Arkansas at that time basically said, they were going to desegregate Arkansas's schools over his dead body. And they didn't. It wasn't over his dead body, but they most certainly set in, I think it was the 101st Airborne Division Eisenhower did, and desegregated the schools of Little Rock. By the way, this is Linda Brown. Most of you probably don't know this, but I think the people sitting at the township listening in today know this. She ended up graduating from Springfield Central High School. Her family moved to Springfield, and she graduated from an integrated school in Springfield. And I can't believe exactly. I'm going to say it was 1958, but I may be wrong on that. All I know is she graduated from Springfield Central High School. Sorry about that. Got ahead of myself here. Okay. Gotta go back. Okay. Now, there have been several landmark civil rights cases associated with the 14th Amendment, expanding the coverage of equal protection that we just talked about under the laws of the 14th Amendment. One of the more critical ones was called U.S. versus Cruikshank in 1876, which prohibited states from denying equal protection of the laws. They said that, didn't do much about it, though. This is a really important one, Korematsu versus the United States. I told you there were 2 or 3 cases in American judicial history that are considered amongst the worst in American history. One of them was Dred Scott. The other one was Plessy versus Ferguson. And this is probably the most recent one, 1944, Korematsu versus U.S., which upheld the internment of Japanese Americans during World War II. So let's look at this case. Again, some of you out there probably remember this. Following the attack on Pearl Harbor, Franklin Roosevelt, who was no conservative by any means at all, folks, he was very much a liberal, signed an executive order authorizing the removal of people of Japanese ancestry from military areas, primarily on the West Coast, because that's where they feared it mostly coming from the Japanese. And what they did, they just rounded up Japanese American citizens. I mean, these people were citizens, and forcefully took them to internment camps in the interior of the United States, Idaho, New Mexico, Arizona, Montana, I believe, Nevada. Some of these interior states of the West housed these Japanese Americans. They were basically sent to POW camps simply because they were Japanese. Most of them were citizens of the United States. My brother, my late brother, happened to have married a Japanese woman whose mom and dad were one of them. He was a lawyer, and her mother was a doctor in San Francisco. They spent much of their early marriage in an internment camp in, I believe, Idaho. It's unbelievable. I understand what the thinking was. I mean, I understand people were scared and upset and mad, much as the same way we were after 9/11. But maybe took it just a little bit too far. Okay, so the question arose. Korematsu sued. He was a Japanese American. He said, "You can't do this. I'm an American citizen. I've not done anything wrong other than be of Japanese ancestry. Did the executive order violating the plaintiff's Fifth and 14th Amendment equal protection rights that restricted civil liberties based solely on his racial background? And the court came back 6-3. And folks, this was the court that basically had ushered in most of the social rulings of the 1930s and early 40s. This was not a conservative court. They ruled 6-3, upholding Korematsu's conviction in the legality of the executive order. They said that the exclusionary order was not racially motivated, but rather a necessary measure to prevent sabotage and espionage. Well, I guess. The case was later revisited by the Supreme Court in 1983, and they overturned the original decision on behalf of Korematsu, stating the previous court had been misled by the government's presentation of evidence. So they ultimately got it right long after the fact. Okay. So that was one case. Loving versus Virginia, 1967, another landmark civil rights case, overturned a Virginia law banning interracial marriage. So let's look at this. This is Mr. Loving and his wife. They lived in Washington, D.C. They were an interracial couple, and they got married. But they returned to Virginia, where they originally came from, and Virginia had a law against interracial marriage called miscegnation laws. They were arrested and convicted to a year in jail unless they left Virginia for 25 years. The state of Virginia said, you can't get married. We will not allow a black and white person to get married. This is 1967, folks. This isn't the Civil War era. We're talking about the fact when I was a sophomore in college, junior college. This happened not that many years ago. Question, did the Virginia law violate the 14th Amendment Equal Protection Clause? And the court came back 9-0, said absolutely. Miscegnation laws, forbidding interracial marriages are absolutely unconstitutional, and the freedom to marry or not marry a person of another race resides solely with that individual and can't be infringed upon by the state. It's remarkable to me that not that many years ago, that was still a law in states. It's just unbelievable to me that occurred not that many years ago. So to say that was a landmark case would be overwhelming. Reed versus Reed, another really landmark case, which I bet most of you have never heard of, but I can guarantee you after I tell you about it, a lot of you will be understanding why it was a landmark case. Struck down an Idaho law, which discriminated against women in probate hearings. So let's look at this. This is Mrs. Reed. And by the way, that was her lawyer in the case, which was Ruth Bader Ginsburg. She was a brand new female lawyer at the time. Ultimately, of course, became a member of the United States Supreme Court. And she took the case and sued. What happened was this. Richard Reed, a minor, died without a will. And his parents, Sally and Cecil Reed, both sought to be appointed administrator of his estate. Apparently, there was some property in his name. However, an Idaho law stated that the males must be preferred to the females in such cases. This was the old, law of ancient Europe, where males were considered to be more important than the females in legal cases. And Idaho, in this case, in 1971, long after I graduated from college, started teaching, at that point in time in Idaho, males had to be preferred over females in administrative decisions in courts of laws. And so the question arose, did the Idaho law violate the 14th Amendment Equal Protection Clause of the 14th Amendment? Decision 9-0 in favor of Sally and Cecil Reed. They said absolutely, the Idaho law was wrong. Said its gender-based preference was arbitrary, capricious, and unconstitutional. It was the first case the Supreme Court struck down a law that discriminated against women based solely on gender. This had a profound effect upon our society, folks, because it wasn't that long after that that you begin to see what was brought into schools and what was called Title IX. Title IX was basically requiring equal facilities, et cetera, things for men and women in schools, particularly when it came to athletic events. Uh, when I started teaching at my old school, there was not a women's basketball team. And in 1972, they started one directly as a result of Reed versus Reed, 1971. Uh, this is the kind of thing that occurred as a result of this case. Of course, now some people would say that we've taken it much greater than that because now the ruling, everyone is agreeing that yes, there should be equality in sports events between men and women, but we all are aware that there is a lot of controversy going on right now in sporting events where you have people, transgender races or transgender sexes participating in events of which they were not necessarily born that sex. And it's created a lot of controversy and probably will continue to do so for some time. So, probably a matter of time before the Supreme Court takes that up as well. So, Reed versus Reed. Then in 1978, there was a case of what was called reverse discrimination. A man by the name of Bakke sued the University of California because they had established what was called a quota system, where they said, when we admit people into our university, we are going to admit a certain number of people of different races, 7%, 10%. And the Supreme Court came back and ruled against that. They said, you can make race one of a factor in deciding admissions, but you cannot mandate that you have to have quotas. Quotas are illegal. Of course, there's all sorts of ways to get around that. Grutter versus Bollinger, 2003, again upheld race-conscious admission systems that use race as one of many factors to determine admission. So the Supreme Court has said there's nothing wrong with taking race into your decision about who should get into your college or university, but you can't make it the sole factor. Whether that has happened or not happened is a area of controversy again in America. So, these are all kind of controversial decisions in one way or the other. Shaw versus Reno prohibited a new North Carolina law which restricted congressional districts with race being the determining factor. Has to do with drawing constitutional lines based upon race. And finally, Bush v. Gore. Boy, how many of us don't remember this? Okay. It served as the basis for the decision by the Supreme Court to halt further recount of ballots in Florida, resulting in the election of 2000 being decided in favor of George W. Bush. He came back and said, I am being denied my equal protection of the law. Boy, how many of us remember this? The Google-eyed ballot counter, trying to determine if the Chad was detached or pregnant, or I can't remember all the names they used, but I can remember this photo so well. I mean, it was like, oh boy, In the 2000 presidential election, several recounts of Florida ballots showing Bush as the winner were challenged by Vice President Gore, and Bush asked the Supreme Court to stop further recounts. There was just recount after recount after recount. And he said, Bush came back and said, I'm being denied my equal protection laws because there are laws in the Constitution and in congressional law that states there is a drop dead date upon which the counts have to be stopped. And he said, we were approaching that drop dead date. And if you don't, stop the recount, which had every one of them had been in his favor, said, if you don't stop this, I'm going to be denied my equal protection of the laws. So did this further recounting of the ballots violate the equal protection clause of the 14th Amendment? And the Supreme Court, in a very narrow decision, halted the recount, which in a sense basically said, there's not going to be any more recounts. And every recount up to that point had him winning the state of Florida by a very narrow margin. And it said, if you continue having recounts, you cannot have one in time to meet what's called the safe harbor deadline established by federal law. Extending the deadline would violate Florida election laws, thus denying Bush's equal protection under the 14th Amendment. What this in effect did was allowed him to be certified as the winner of Florida's 25 electoral votes, which allowed him to have one more electoral vote than was needed in the presidential election. Of course, a lot of people still don't agree that that was illegal, and I understand why they would feel that way. I also understand what the law says, and the law says basically that there is a date certain where recounts and votes have to be certified, and if they're not certified, then they can't be, the election can't be certified, period. And so the Supreme Court came back and said, you can't continue doing this. We've had several recounts, hand recounts, computer recounts, and it's got to stop because, there comes a point when you can't continue on with this. So this was that case. Okay, well, I've gone a little bit over. I thank you for being with me. I hope I've muddied water again, just like always. Next week, we're going to try to finish this up. And I promise you that if we get through this next week, we will start in 2 weeks' time a whole brand new set of presentations, which I think you're going to find really, really interesting. I've been asked by several people in the past to do something on the Civil War, and I've always kind of hesitated because, frankly, I'm not a military historian. And I wanted to make sure I could do this so it would not be a military history. Now, that being said, you can't talk about the Civil War without talking about the battles. But it's going to be much more than that. Okay. We're going to, we're not going to go into intricate detail with the study of each battle. I'm not capable of doing that. I'm not a military historian, but I do know the Civil War, and we're going to talk about it. And it's really, I think it's going to be really good. So I encourage you to tune in 2 weeks' time. Tune in next week to finish this up, and then we'll go from there. So I appreciate it. I will let you go, and we will see you next week. We'll finish up American Genesis. So long.